Hello and welcome back to Q&A Land Law Edition Part 2. I'm your host, Professor Umar, and now we will continue our program with another two problems that we have received from our caller. But before that, as you all know, our program has received a high star rating of 28 stars over 30, and I would like to thank all the viewers who have rated and loved our program so much. Without further ado, let's look into our first situation where we have two issues that we need to answer, given by a duo of callers named Bada and Sami regarding their friend Salim, who has troubled them with their land. Now let's answer the first issue, which is whether Bada has the right to refuse Salim's payment unless Salim pays an additional sum of 1,000 being the payment for service and charge. For those who don't know, this issue is regarding Jual janji, which can be defined as a sale of a promise in the form of conditional sale, where the land is used as security to secure the loan, which is small in size and value. The concept of Jual janji, for those who don't know, is allowed under our National Land Code Act under Section 4, Clause 2, Clause A. And this is even supported by the case of Tengku Zara against Cik Yusof, where Briggs J stated that the whole purpose of Jual janji transaction is to provide a procedure for securing a loan without infringing the prohibition of usury. To further discuss this issue, I would like to invite our first panel, the knowledgeable and wise Dr. Akmal, Land Law Lecturer of University of Lien Union, to explain what are the approaches of the court regarding Jual janji. The floor is yours, Doctor.
Thank you, Prof. Umar, our Selangor Royal Land Commission advisor. Thank you for inviting me here today. Now let us proceed with the issue. As our Mr. Moderator had precisely explained what Jual janji is, now I would like to explain the type of Jual janji. Now in the court, there are two approaches of Jual janji. The first approach would be the strict approach. In a simple word, the strict approach, the court regard the time as of essence. The landmark case would be the case of Haji Abdul Rahman, when the court dismissed an application made by the borrower who paid down the loan 18 years beyond the deadline. While a liberal approach would be that the collateral agreement for retransfer in Jual janji transaction is in nature of an equitable security transaction whereby the right to redeem remain irrespective whether the period for repayment has lapsed. The leading case would be the case of Yaakob bin Lebai Jusof, when the Court of Appeal found evidence indicating the land was mortgaged to ensure the repayment of $2,000 even though the loan payback time has elapsed. However, most of the time, the court would rely on the judgment in the case of Haji Abdul Rahman, as mentioned by the Lordship in the case of Hatijah binti Rajab against Abdullah Sa'ad. They were hesitant to depart from the strict approach in Haji Abdul Rahman case. Ladies and gentlemen, even though the strict approach elaborate the time is essence, there is exception to this general rule. In the case of Ahmad bin Omar, the court found the defendant avoided plaintiff payment, made him unable to pay the debt as stipulated in the contract. The court held that if the conduct of the parties show that time is not the essence, therefore, it was no longer so. Now, referring to the case of Hatijah Rajab, Malaysian court are more persistent in using this strict approach. Unless there is any unexpected fact, therefore, the case shall be distinguished from the case of Yaakob bin Lebai Jusof, due to the reason that there is a lack of fact in the case that exhibit the collateral contract be an equitable security transaction. Hence, referring to the case of Haji Abdul Rahman case, generally what had been stipulated in the contract shall be followed. This means that if Salim had overdue the payment, the court would not assist Salim in retransferring the land. However, followed the case of Ahmad bin Omar, as stipulated in the case, avoiding or evading the payment can be regarded as the act of the party disregarding the time in the contract. Therefore, even though Salim failed to pay the money on time as constituted in the agreement, due to the act of Bada evading the payment means the party to the contract has disregarded the time. Even though the amount demanded by Bada can be said to be reasonable, the fact that he increased the amount of payment to RM 16,000 due to 1,000 as a service charge shows that he had disregarded the contract made prior to the new proposal. Hence, the time is no more an essence in this case. Therefore, Bada does not have the right to refuse Salim payment and ask Salim to pay an additional sum of 1,000 for the service charge.
Thank you, Dr. Akmal, for the thorough discussion about Jual janji and solving the first issue just now. I would like to further continue our show today. The second issue that is present is whether Sami is entitled to a lien over the land in Shah Alam. Now, what is lien, you may ask? Lien, according to our National Land Code, specifically Section 281 Clause 1, state that it is a type of security transaction whereby the registered proprietor of the land deposits his issue of document title or IDT to the lender or creditor as a security for the loan advance. And this is even backed by our common law, namely the case of Palanapia Chetty against Dupaya Brothers. To further elaborate about Lien and its many elements, I would like to present to you our second panelist for today, who is a favorite fan of many, Dato Sri Hakif, Senior Partner of Tanah Pusaka Associates. Please enlighten us with what are the elements of Lien to solve Sammy's issue.
Thank you, Professor. I will attempt to analyze the elements in light of the issue faced by Sammy. The first element is deposit of the original issue document of title in case of registered proprietor or duplicate list in case of registered lessee. After 2008, a registered proprietor may deposit his identity as a security of a loan advanced to a third party. This can be seen in Hong Leong Finance and Stockholm's Number High, where the court allowed Lien to be created over a third-party loan, provided there is an authorization by the registered proprietor for the borrower to use the proprietor's land as security for a loan granted in favor of the borrower by the lender. Let's get right to the application. Since the deposit of the identity was not done by the registered proprietor, namely Salim's brother, but was done by Salim, which is a third party to the land. Salim's brother need to consent for the identity to be deposited and his land to be used as the security for the loan. Thus, applying the case of Hong Leong Finance, Salim's brother, who is the registered proprietor, was strict that the identity was needed for subdivision instead of loan. Therefore, he has not consented nor authorized for the identity to be used as security for a loan, as this was not bring to his attention. In this case, the first element is not fulfilled. The second element is the keeping of the identity at all material time by the lender. This is as a proof of the interest of the said land. This is affirmed in the case of Sitambaram Chetty and Ramanathan Chetty, where the court held that the defendant lost his right as a lien holder the moment he parted with the identity, and his caveat was removed from the registered document of title. However, in certain circumstances, parting with the identity will not cause the right of the lien holder to be lost. For instance, according to section 281 subsection 4 of the National Land Code, a lien holder may part with the identity by producing it at any registry or land office for any purpose required under the National Land Code upon the written request of the registered proprietor or lessee. Now, the application for this element is short and simple. Since Sammy as the lender has maintained the identity as there is no evidence that he had parted ways with it, the second element is fulfilled. Furthermore, the next element to create a statutory lien is an entry or lodgement of a lien holder's caveat. The lender or creditor may enter into a lien holder caveat through Form 19D, after which the lien will then come into effect as provided under Section 281, Subsection 1, Paragraph A and Paragraph B, and also Section 330, Subsection 1 of the National Land Code. This provision provides that the lender or creditor may apply for entry of lien holder caveat. The effect of the lodgement of the lien holder caveat is the lien will be covered by the National Land Code and it will restrain all dealings with the land. In addition, in the event of default by the borrower, the lender is entitled to invoke remedy available under Section 281 Subsection 2 of the National Land Code, namely for the order for sale. Thus, the lender or creditor will be treated as a lien holder for the purposes of the National Land Code only upon the entry of the caveat. This element was referred to in Palanyapa Chetty and Dupaya Brothers, where the court held that only the lender or creditor to whom the identity has been deposited may enter into the lien holder's caveat. However, lien holder's caveat can be entered at any time, and failure to caveat timelessly will not, for that reason alone, cause the prior uncaveated lien to lose priority against later caveated interest, as it will become equitable lien. Therefore, applying this principle based on the facts, a lien holder caveat was lodged by Sammy on 3 February 2022 on the Shah Alam land. Hence, the third element is fulfilled.
I beg your pardon, Datuk Sri Hakif. I agree with what you have said earlier, but I think you have forgotten one element, which is the critical element in this issue. The element is the intention to create lien. Without intention, any act of deposit is merely a matter of convenience in a view of possible sale or simply for safekeeping. The type of transaction entered into by the parties must be for loan transaction only. No other intention such as sale and purchase agreement. In the case of Nalamal and another, in this case, the court held that the intention is not satisfied if possession of IDT was obtained through fraud or misrepresentation, and the deposit of IDT as security was never authorized by the registered proprietor. Therefore, intention of the parties can be determined through the type of transaction entered into by the parties, the conduct of the party as a whole, and the nature of the agreement. This is supported by the case of Standard Chartered Bank against Yap Sek Yong, when the court held that a loan transaction, if the lender or creditor is in possession of the IDT, is sufficient to constitute an intention to create a lien. In addition, in Paramo against Zeno Limited, it must be proven that there is an intention to deposit the IDT or duplicate lease with the lender as a security for the loan and no other purpose. Back to our issue, I think it is a clear cut that in this case, there is no intention that is present from the registered proprietor of the land, that is Salim brother. Since Salim lied and took the IDT purposefully for subdivision of land, although the deal is for a loan transaction and there was intention from both Salim and Sami, but the lack of intention from Salim brother, who is the registered proprietor of the land, is what failed this element. Hence, did not fulfill the last element. All in all, Sami cannot rely on the lien created over the land in Shah Alam due to the element of deposition of IDT and intent is not fulfilled.
Thank you so much, both of our panelists today. Let us continue this show with the final problem given by our caller named Hussein.
The issue for the second question is whether Bank Damai Hati Berhad may take possession of Hussein's shop house.
Now, what is charge? Charge can be defined as a registered charge according to Section 5 of the NLC, and its main purpose, according to the case of Yi Sin Cheng against UMBC, is to secure the repayment of a debt and for the payment of any sum other than a debt. Its formal definition can be said to be a dealing where a particular property is used by the registered proprietor of land or registered lessee as a security for the repayment of loan advanced to him or any third party, with the condition that such dealing is registered at the registry or land office. I would like to further continue this discussion by once again inviting Dr. Akmal to share with the audience the rest of the components in charge.
Thank you, Prof. When talking about remedies, there are 3 remedies a chargee can seek, which are order for sale, taking possession, and assignment to dana harta. In this situation, taking possession is the most suitable way for the chargee. Now, what is taking possession? Taking possession is applicable when the charger is in breach of the agreement stipulated under Section 271 subsection 1. Taking possession is used when the market value of the charged land is not suitable to be sold. However, there are a few limitations in pursuing these remedies. As stated under Section 270 of the NLC, it is not accessible to any land held under land office title or the corresponding form of qualified title. Moreover, it is not accessible to any charge of undivided share in alienated land. The land shall not be occupied by the charger. And lastly, it shall be accessible by first chargees only. There are 2 manners of taking possession, Section 271 of the NLC, which are constructive possession and actual possession. First, let us look into procedure for actual possession under Section 272. I will illustrate it using the case of Malaysian Credit Finance Berhad against Yap Hong Chun. The procedure would be chargee serve notice in Form 16K to the charger. Then, charger admit or secure the admission of the chargee. And lastly, chargee can enter into possession of the land. However, let's say chargee failed to serve notice in Form 16K to the charger. Then, chargee cannot enter into possession of the land. However, it is different when charger failed to admit or secure the admission of the chargee. When this happens, chargee can apply to the court for an order for possession. Then, after that, chargee can enter into possession of the land. Therefore, this case upholds the principle that service of notice in Form 16K is mandatory in taking possession.
Thank you, Dr. Akmal. Dr. Hakif, how do the court interpret this provision in one of the limitations earlier that the charges shall not be in occupation of the land?
Thank you, Professor, for the questions. So, the interpretation of the court can be seen in the case of Malaysia Credit Finance Berhad, where the plaintiff, which is the chargee, applied for an order of possession in the High Court for actual possession. However, the chargee failed to serve notice in Form 16K to the defendant, which is the charger. Therefore, as the service of notice in Form 16K is mandatory for actual possession, the court dismissed the application by the chargee for an order of possession. After that, the chargee had taken steps to serve notice in Form 16K to the charger. Nevertheless, the charger in occupation refused to open the door for possession, and the chargee made another application for an order of possession in the High Court. The chargers argues before the court that no remedies of possession is available against the chargers in occupation of the charged land, as stipulated under the limitation in section 270, subsection 1, paragraph B of the National Land Code. However, the court held that since Form 16K had been served, the chargee is entitled to file the application as it has complied with section 272, subsection 3 of the National Land Code. In regard to the limitation, the court states that the word not under section 270, subsection 1, paragraph B should be disregarded so that land presently in occupation of the chargers will be amenable to a claim for actual possession under section 271, subsection 1, paragraph B of the National Land Code. Moreover, Prof, I would like to highlight the duration of possession as stipulated under section 273, subsection 1 of the National Land Code, where a chargee in possession can remain in possession until the loan remains unpaid. Be that as it may, the chargee has the right to relinquish his possession at any earlier time. Other than that, the effects of taking possession can be inferred from section 274, subsection 1 of the National Land Code, whereby a chargee is entitled to manage the land and take all profits thereof. However, it is important to note that the chargee shall be liable to the charger for any act whereby the capital value of the land is impaired or the charger is put to any loss. This is further specified under section 274 subsection 2, where the chargee shall be accountable to the charger not only for all sum actually received by him, but also for any additional sum which he might be reasonably expected to receive. For instance, in the case of Un Fun Ho and Mutia Chetty, the charger claimed that the chargee failed to cultivate the land by not tapping the tree for over 2 months. The court held that the chargee is liable to account for the charger for the profits the charger might have received by cultivating the land with reasonable diligence during the period.
Thank you, Dato' Haki, for the explanation of the law. Now, I would like to further our show with the application part. Firstly, I think we can identify the position of the parties easily, where Hussein is the charger and Bank Damai Hati is the chargee, with Hussein Shop House as the charged land in consideration with the loan that has been approved amounting to 250,000 ringgit. Now, I would like to come back to Dato' Hakif to answer whether Bank Damai Hati can take possession of Hussein Shop House.
Thank you, Prof. It is submitted that by applying the limitation stated in section 270, Bank Damai Hati Berhad as the chargee is entitled for the remedies of taking possession. This is because the charged land is not land held under land office title or corresponding form of qualified title, but the land is held under registry title as the shop house title number HAs in bracket D 2003 PT number 34 connotes that it exceeds 4 hectares and thus a registry title. Secondly, the charged land is not an undivided share of land as Hussein is the sole registered proprietor of the charged land. Thirdly, Bank Damai Hati is the only chargee who gave the loan to Hussein and there is no subsequent chargee for the said land, and therefore the limitation on the first chargee should not be an issue here. Next, by applying the case of Malaysia Credit Finance Berhad, although Hussein lived at the shop house and in occupation of it, Bank Damai Hati Berhad as the chargee is still entitled for the remedy of taking possession. Applying the same case, Bank Damai Hati Berhad had served notice in Form 16K to Hussein as the charger for actual possession. Thus, Hussein should admit or secure the admission of Bank Damai Hati Berhad within the period specified in the notice.
I'm sorry to interrupt again, Dato', but I believe that the situation of the charger does not want to leave the building or the land realistically happened in Malaysia. Now, if this happened, we can refer back to the case of Malaysian Credit Finance Berhad, as alternatively, Bank Damai Hati Berhad may apply to the court for an order for possession under Order 83 of the Rule of Court 2012. Now, back to you, Dato'.
Thank you, Dr. Akmal, for your interruption. And yes, I totally agree with you. Now, moving forward, when Bank Darmahati had entered into possession of the shop house, they can remain in possession until Hussein has paid the amount due to them. However, they can relinquish the possession at any time. Thus, Hussein needs to pay the sum due from the loan of 215,000 ringgit in order to get back his land from the possession of the Janji Bank. Alternatively, Hussein may get back the land in the event Bank Darmahati Berhad had relinquished possession even though the sum due has not been paid. The effect of this is that Bank Darmahati Berhad can manage the land and take all profits during the period of possession. However, Hussein can claim for damages if the capital value of the shop house is impaired or is put to any loss. In conclusion, Bank Darmahati Berhad may take possession of Hussein's shop house.
Since we have reached the conclusion for the third issue, this means that our show has come to an end. But before that, I would like to recap to you our findings in each issue that we have discussed. In the first issue, Bada does not have the right to refuse Salim's payment and ask Salim to pay an additional sum. Secondly, Sami cannot rely on the lien created over the land in Shah Alam. And for the third issue, Bank Darmahati may take possession on Hussein's shop house. With that, thank you so much for tuning in and watching us. Thank you to our panelists and all our viewers. We appreciate your support. Hope to see you next time and have a good day. Goodbye.